Assurance Commission. Today's date is April 1st, 2011. The time is 9:05 in the morning. This administrative proceeding is being conducted at the Department of Health facility in Tumwater, Washington, and is being conducted in accordance with Chapters 3405 of the Revised Code of Washington, which is the State Administrative Procedure Act, and Chapter 18130 of the Revised Code of Washington, which is the Disciplinary Act. My name is John Kuntz, and I am the Health Law Judge assigned by the Secretary of Health and authorized by the Medical Quality Assurance Commission to conduct this administrative proceeding. Members of the Commission who are present and who will be making the decision in this matter: to my far left, Dr. Berger; to my immediate left is Dr. Brantner; to my near right is Mr. Concanon, public member; to my far right, Dr. Cullen. It is these four gentlemen who will be making the ultimate decision in this matter, and they will advise me at the conclusion of the hearing as to their decision. I will reduce that decision to written form and will serve that upon the parties. Prior to the hearing, I distributed to the panel members the department's 2 exhibits and a package of documents which is known as the hearing packet, which consists of the statement of charges, the answer to the statement of charges, and a copy of the sanction rules, which are administrative rules which are used to determine sanctions in administrative proceedings. Present in the hearing room, I'm representing the Department of Health Medical Program is Kim O'Neill, Assistant Attorney General. Also present in the hearing room and representing himself is Dr. Gaston Cornu-Labat, and this is master case number M2010-84. Prior to the going on the record, doctor, let me explain the record. It's digital. I'm recording it. So long as you see the clock running, that means the record is on. There are microphones on the desks, microphone at the witness chair, and I have microphones up here that are strong enough to pick up comments and discussion from the panel members. I note, looking out into the audience, there are 1, 2, 3 video cameras. There had been no previous discussion that this hearing was to be videotaped. Dr. Cornu-Labat, do you wish to address that issue?
Certainly. There was no previous discussion because on consultations with my attorney before his withdrawal, I specifically asked if there was any rule in this regard. He told me that there was none, and my assumption, being this a public hearing and being this so fundamental in the issues that will be discussed, was that there would be no problem in terms of having a recording. I believe it's very important to have a recording of this hearing.
Thank you. Ms. O'Neill?
The procedural rule is that it is at the discretion of the presiding officer, and only if it's not disruptive or interfering with the conduct of the hearing. The usual concern is whether witnesses will be affected by or intimidated by it. The department doesn't have witnesses that are likely to have that problem. I think it should be clear on the record, though, that whatever the videotape picks up, the only official record of this hearing will be the one that the presiding officer is keeping, that is being recorded only by audio recording.
And I'm also assuming that if I do rule to allow videotaping, that the department would want copies of all of the videotapes?
I would ask for that. We've sometimes gotten them and sometimes not. But yes, I would request that.
Okay. So, Doctor, just to piggyback on what Ms. O'Neill said, she's correctly stated the law. In fact, what I'm referring to is the Revised Code of Washington, section 34.05.449, subsection 4, Ms. O'Neill correctly states that additional recordings may be made during the hearing if the making of those additional recordings does not cause distraction or disruption. These are issues that are normally discussed at the pre-hearing conference. Your attorney, I will note for the record, Dr. Cornu-Labat previously had an attorney. That attorney has withdrawn. Dr. Cornu-Labat is therefore representing himself. And doctor, what I will say to you is, so long as you're acting as your own attorney, you're expected to know all of the procedural rules and all of the legal rules that apply in such hearings. However, I will allow videotaping of this administrative proceeding so long as individuals I see three, as long as those individuals understand that they're allowed to videotape if they do so quietly, if they do not disrupt the proceeding, and that they do not videotape any witnesses that indicate to me at the beginning of their testimony that they choose not to be videotaped.
I agree completely with that, and I think that people that are videotaping are expected to be taped appropriately. At least that was the plan. So I cannot anticipate any problem with that.
If at any time I believe that they are exceeding the instructions of this court, I will ask them to leave.
Certainly, it's completely in your power to do that.
Thank you. So Dr. Cornu-Labat, just by way of explanation, administrative hearings follow a certain format. Each side will get to make an opening statement, which is just a short statement of what they intend to prove at hearing. Each side will get an opportunity to introduce witnesses, and each side has an opportunity to introduce exhibits. Normally in a pre-hearing conference, the exhibit packages have been gone over with me prior to the hearing. An exhibit package was submitted by your previous attorney, and I have made two separate rulings in pre-hearing orders number 3 and 4, I believe, based on the limited scope of this hearing, that the hearing package which was previously submitted by you, and from now on I'll just say you instead of referring to your previous attorney, that I ruled that those exhibits were not relevant because of the very narrow scope of today's administrative hearing. And the scope of today's administrative hearing is set forth in the statement of charges. Specifically, the issue at hearing today is whether you, doctor, failed to comply with an order issued by the commission. And that's what the hearing will be about. The two exhibits which were previously submitted by the department consist of a notice of intent to order examination and order requiring examination. Those have been distributed. I will admit those documents. Dr. Cornu-Labat, do you have exhibits that, other than the ones that were previously submitted to my office?
There is nothing new other than what has been previously submitted.
Thank you, Doctor. One other thing that I will tell you about administrative proceedings that is different than civil trials is that panel members will be given an opportunity to ask questions at the point in the proceeding when testimony has been elicited from the witness or witnesses that are put on the witness stand. It should become apparent after the first one how the system works. While I am presiding over this hearing for this commission panel, I am not a decision maker. I will not have a vote in the outcome of this proceeding. Before we move forward, let me just check one more time. Ms. O'Neill, any procedural issues that the program wishes to raise? Excuse me, the party wishes to raise?
Not for the department, no.
Thank you. Doctor, do you have any questions before we go forward?
No questions.
Thank you. Then I'd like to give the parties an opportunity to make opening statements because the department bears the burden of proving its case. Ms. O'Neill gets to go first. Ms. O'Neill.
Thank you, Honor, members of the panel. We're here today on a very narrow and simple question, which is whether Dr. Cornu-Labat has complied with an order previously issued by the Commission that he submit to a specifically described examination. The Department's allegation is that he has not done so, and if you find that the proof establishes that he has not done so, then you will be asked to impose a statutory sanction. It's a little bit different than most of the cases you hear, because the statute 18-130-170 spells out what the sanction is supposed to be. There is no sanction grid in the sanction rule that applies in this case, so there's no range that you have to consider, or aggravators or mitigators that you have to decide when you're imposing the sanction. By statute, the discipline is supposed to be a suspension of the license until he complies by getting the examination and submitting the results to the Commission. So 18-130-170 subsection 2 is the statute that governs the proceedings before you today. It sets out a procedure if the Commission is investigating or adjudicating a complaint that indicates that a licensee may not be able to practice with reasonable skill and safety. The Commission may order that licensee to submit to a mental and or physical examination. When the Commission makes the decision to do that, it must issue a notice of intent to the licensee, notifying him that the Commission intends to order such an examination. Upon service of that notice, the licensee has an opportunity to answer and either agree to get the examination or indicate he disputes the order and intends to resist that. If the licensee indicates that he does not agree to get the examination, he has an opportunity to submit whatever evidence or documentation he chooses to the Commission. The Department also files with the Commission the documentation, the supporting evidence for why that examination is necessary. A Commission panel who has not been previously involved in the allegations regarding that licensee considers both sides' written submissions and makes a determination of whether to order the examination. That has already happened in this case, and the Department's exhibits include the notice of intent to order an examination which was issued in this case. Dr. Cornu-Labat received that. He indicated he wished to resist that order. Both sides submitted written documentation, and an order was entered requiring Dr. Cornu-Labat to submit to a mental and physical examination. That order, the notice and the order, are the two exhibits that the Department is putting in front of you today. That order was issued. It specifies 2 local practitioners that Dr. Cornu-Labat can choose from to obtain the examination, and it lays out what the examination is supposed to consist of. The order also requires that the Commission have access to and communication with whichever provider is chosen to perform that examination. So that order was entered. It was entered in September of 2010. It was served on Dr. Cornu-Labat, and it is the Department's contention that he has not submitted to that examination. Among the arguments that I expect that you'll hear from him is that he got his own examination from providers that he chose, that were not approved by the Commission, that are not in compliance with the order, and the statute has a specific provision in it, in sub 2, sub C, that says, in addition to any examinations that the Commission orders, Dr. Cornu-Labat is free to provide you with other examinations from other providers.